Gus was an assistant county attorney, and yes, he is the son of our city councilman, Garcia, and is in line to be perhaps on the new county court law project. So y'all be nice to him. And as I already introduced Tom O'Leary to you, he will be doing the defense board. They're of course sitting at the wrong tables, but and I'm going to do I'm going to be the judge. David having lost himself in the back of the room conveniently. Okay, and when they're finished, they're going to give you kind of their theories of voir dire, and y'all feel free to ask questions about what they did or didn't do.
Do I have a victor?
No,
Okay.
you're defending an empty chair.
All right.
The court calls State of Texas versus Victor Alvarez, cause number 123456. What says the state?
State's ready, Your Honor.
What says the defense?
We're ready, Your Honor.
The court needs to take a brief recess to get here. Okay, Mr. Garcia, you may resume whenever you're ready.
Hey, police court, counsel, members of the jury, good afternoon. My name is Gus Garcia. I'm an assistant county attorney here in Travis County, and you've been called in here to serve as jurors. Some of you will be chosen as jurors in a criminal case, and the case that we'll be presenting to you is a case in where Victor Alvarez has been accused of driving while intoxicated. And this is not a civil case. This is a misdemeanor trial that 6 of you will be presiding over as jurors. During this phase of the trial, I will be asking you questions about your attitudes towards the law and towards the crime itself of driving while intoxicated, in order to find out if you have any ideas, biases, or special knowledge that would make you fit, or maybe make you not just the right juror for this kind of a trial. For example, my house has been burglarized, and I've had a lot of possessions of mine stolen, and it was a very bad thing that happened to our family. And if I were a juror in a burglary case, for instance, I don't know if I could be the fairest of jurors. And at this phase of the trial, this is a time where I'm going to ask for your opinions, and I ask for you to be forthright with me. I don't mean to put anybody on the spot, but if you will please talk with me about the issues arising out of a DWI case. First of all, there is a legal definition in Texas in that driving while intoxicated, that a person is guilty of a crime if he is driving and operating a motor vehicle while intoxicated. And the intoxication definition is critical in a DWI case. It has to do with loss of normal use of mental faculties and or loss of normal use of physical faculties. And there's a presumption that if a person blows into a machine and gives a sample of over 0.10 breath alcohol content, that can also be used as evidence. So the first part of the voir dire examination, Mr. Daly, just in your, give me your definition of what intoxication means and compare that to what you think that compares to if I say somebody is drunk. So what is it, the difference between, in your mind, between somebody being intoxicated and somebody being drunk?
I think intoxication is just, you could be intoxicated after you have a couple drinks, whereas with drunk, I think you're just stumbling around, showing obvious physical effects.
Mr. Burleson?
I would say I agree with that. I think of drunk as a higher level of intoxication than just intoxicated.
Ms. Ford, do you think any differently than that?
Well, I think that intoxicated is, like you said, anything less than the normal use of your mental or physical faculties, and would be intoxicated. And I think that drunk, includes being intoxicated. If you're drunk, you're obviously intoxicated.
So it's fair to say that
You can be drunk and intoxicated, but you don't have to be intoxicated and drunk.
intoxicated therefore somehow means less than just commode hugging drunk type, or falling down drunk type.
That's what I think.
Mr. Bird, do you think it's against the law to somebody to have 2 or 3 or drinks at dinner and then get in his car and drive?
I don't think it's against the law. I mean, if they're in control and can operate a vehicle properly. And, as long as they're not legally intoxicated, I don't have a problem with that.
That's an important point to make at this time, that the prosecution here is not saying that, hey, it's against the law to drink and then drive. The crime is, the allegation here is driving while intoxicated. So we don't mean to contemplate here that we're prosecuting a behavior having to do with just a simple consumption of alcohol at dinner, for example, and then later on driving if a person feels that he can do that. Mr. Bird, how would you describe, in your own words, how intoxication may manifest itself in a driving situation?
I would say swerving, being unable to maintain a steady speed. I think those would be signs of intoxication.
What about on the person, observing the person himself or herself?
Not being able to speak, clearly slurring, swaying when they're standing.
What about reaction times, Ms. Ford?
Yeah, I definitely think that if someone was intoxicated, something that would normally take them 10 seconds might take them 11 seconds when they were intoxicated, or more time to react.
So the situation of the little boy darting in front of your car to chase a ball, how would that be affected by someone who's possibly intoxicated, Mr. Burleson, versus someone who hadn't had anything to drink?
I would say, first of all, the intoxicated person's probably less likely to see the little boy dart out in the first place. I mean, they may not be paying as close attention to everything around them. And if they do see them, it's probably going to take them longer to swerve or react or hit the brakes or whatever it is they would do to avoid hitting the boy.
So it's a societal interest for protection of the public safety on the roads is sort of a rationale for enforcement of these DWI laws, and that's a perspective that we ask all potential jurors to take into consideration. In many DWI prosecutions, you'll hear defense lawyers say, well, this is just merely an opinion crime. It's only in the opinion of some police officer. Let's take the example of when somebody refuses to take a breath test or blood test, and the officer simply just arrests a person based on his opinion. Mr. Burleson, can you give examples of what possibly a person would use in forming an opinion that somebody's intoxicated?
Some of the physical manifestations that Mrs. Ford mentioned, I think, would be good indicators. Not able to stand up without swaying, or perhaps it was Mr. Bird. Maybe the smell of alcohol, lack of balance.
Do you think it's unfair that somebody could be prosecuted for driving while intoxicated and arrested for driving while intoxicated merely based on the opinion of a police officer that said that person was intoxicated?
I guess it would depend on, what I thought of the police officer after listening to him.
Would any of you here on this panel require the state to provide scientific evidence of intoxication before being able to convict? Mr. Daly, would you?
No. But I agree with him, I think it depends on circumstances. If the cop's just outside a bar waiting for people to come out, kind of like almost entrapment. I don't know.
Has anybody here on this panel heard of what's commonly referred to as field sobriety tests, Ms. Ford?
Yes.
What does it mean to you when you hear the term field sobriety tests?
Well, they're tests that the officers administer right when they first pull the, I guess, the defendant Victor over to determine whether they're intoxicated or not.
Mr. Bird, have you heard of field sobriety testing
Yes, I have.
in context with the DWI investigations?
Yes.
Do you have you heard anything through discussion with friends, neighbors, relatives as to any kinds of what specific tests they are?
Yeah, I know.
Like
kind of
what?
test. Walking the line, shining the lights in your eyes, ABCs backwards, that kind of stuff.
Just in your own opinion, why do you think those kinds of tests are used by police officers in DWI investigations?
I think they use them to, I guess gauge whether the person has been drinking and whether they think they've had too much to drink.
And what do you think those tests show? For instance, one test is to lean with your head back and stand still.
Well, then I guess it can show you've had too much to drink and you don't have good balance, or you have a case of vertigo or something. I don't know.
Well, that's good. The tests are there to determine physical faculties. We get back to the legal definition of intoxication. Normally, the prosecutor would have a big chart here of the definition, and I didn't prepare one. But one of the standards, the legal definition of intoxication is, has the person lost the normal use of his physical faculties? So wouldn't it be a fair test to say, well, let me administer a couple of physical faculty tests? So therefore, you're converting a quote-unquote opinion of a police officer into something concrete, a performance on a test that tests a person's physical faculties. How would you go about, for instance, just in your own creative imagination, Mr. Daly, come up with a test for a policeman to use to test for mental faculties?
I guess you just start asking questions as far as like who's president, what state are you in, stuff like that.
One of the common ones is asking a person, as simple as it sounds, is to recite the ABCs. These kinds of things are things that police officers use in order to make a determination as to whether somebody has lost the normal use of their physical and or mental faculties. Mr. Bird also pointed out another important factor in that determination is the kind of driving that you see. Let me ask a question. If you were to learn, or let me just say hypothetically, if it was a situation in which you said, well, the policeman said that there was really no bad driving, that the person was going 55 and a 45 mile an hour, and so the policeman pulled him over, and then later, as a result of field sobriety tests or investigation on the scene, the person was arrested for DWI. Does that bother you, Ms. Ford, that there was no bad driving, but nevertheless the policeman has made a decision to arrest somebody for DWI?
Well, if he's gonna arrest him for DWI, I'm gonna assume that he went through the steps afterward, administered the field sobriety test or did something to make the determination that he was intoxicated enough to bring him down to the station.
Is anybody here bothered by any kind of prosecution that would involve normal driving, other than say speeding, and then that could lead to someone being arrested for DWI? Mr. Burleson?
When you say normal driving, are you excluding speeding?
Excluding speeding,
driving in their lane, going the speed limit, signaling for turns, that's what you mean by normal driving?
Yes.
I would probably have a problem with someone being arrested for DWI if they were driving properly.
What if the only thing that he was doing wrong was a busted out tail light and he was still arrested? Everything else was good driving.
That would probably bother me some.
Anybody agree with Mr. Burleson on that?
I think I would have to agree with him.
What if the only bad thing was speeding and that was the only reason the policeman pulled him over was speeding? And then the policeman said, yeah, he was speeding, and then I got him out of the car and realized he was intoxicated and I arrested him.
They give him a breath test?
Not at the scene. Just based on field sobriety tests and whether the policeman says, hey, I smell the odor of alcohol on his breath.
No. I think I have a hard time with the police officer being the judge and the jury in that situation.
So you would
I
require,
mean, was the guy throwing up or did the policeman just smell a beer on his breath?
let's just say he didn't throw up. But in the officer's opinion, he failed the field sobriety tests. And took him to jail based on that. Does that bother you? If there was no bad driving other than going 10 miles an hour over the speed limit?
I mean, I don't, one of these gentlemen down at the end brought it up. I guess I would have to see what the cop had to say and see how I felt about the cop.
Well, clearly I can't present any evidence to you at this point, and I'm not trying to pin you down on a hypothetical, but I'm just asking you, is it bothersome to you to the point that you don't think you could sit on a DWI jury, to the point where I can't sit on a jury, Mr. Garcia, if you don't bring me evidence of bad driving?
5 minutes, Mr. Garcia.
Would it change your opinion at all if I told you that there was alcohol found in the car, unopened bottles? Mr. Daly?
Why did you stop the car? Was it
Just 10 miles over the speed limit. No other bad driving.
Okay. And then the only thing he saw of the person was the open bottles, is that right?
And in the officer's opinion, failed the field sobriety test.
Oh, I think that's enough.
Anybody here, let me pick Ms. Burt or Ms. Ford, do you have an opinion that field sobriety testing is a fair and legitimate way for police officers to test for sobriety?
I sure do. My opinion is that I think that they have to do something to get them from the car to the station, and they're trained, and I feel that, you know, maybe to us it may not be may not make sense, or we might not think they're the best test, but I think that they're trained and they know what they're doing.
In the interest of time, I'm going to cut to the end, but anybody here contribute money to Mothers Against Drug Driving or serve on the board of Mothers Against Drug Driving, the organization MAD? Anybody here ever had a loved one, a relative, a friend, ever hurt, maimed, injured, or killed by a drunk driver? And the last thing that I talked to you about is we are held to the standard as prosecutors, and we must convict this defendant. We must present credible evidence to you beyond a reasonable doubt that he is guilty of this offense. And I want you to hold me to that standard. If you feel in any way that I have not proven this case beyond a reasonable doubt, I want you to acquit him. I want you to understand that this defendant has many rights in American justice system. He has a right to a competent attorney. He has a right to subpoena any witness he wants to. He has the right to remain silent, and I cannot compel him, nor can the judge compel him to testify. The Fifth Amendment. He has the right to see my whole file. I've given him and his lawyer access to my complete file, and those rights are important parts of the American justice system, and I ask that you abide by those rights and hold me to the standard of proving this case beyond a reasonable doubt. Thank you, Your Honor.
Thank you. Mr. O'Leary?
May it please the court, Mr. Garcia. Well, good afternoon, ladies and gentlemen. As you have heard, the judge introduced me. My name is Tom O'Leary, and I'm an attorney here in town. And as you can see, I'm here today with my client, Victor Alvarez. And as you know by now as well, Victor has been accused of a very serious crime. He's been accused of driving while intoxicated. And just as Mr. Garcia wanted to get some information from you as well, we would like to have some information from you to make sure that Victor gets a fair trial. And Victor, I want you to stand up for just a second. This is Mr. Alvarez, and he is a student at the University of Texas. He is also an engineering student. He was in his sophomore year when he was arrested. The court system has taken several months, so he's now a junior. He's doing well. Go ahead and have a seat, Victor. Some of the things that I'd like to talk to you about, for instance, are Victor is not an American citizen. Victor is from Nicaragua. And I would like to pose, I guess, first to you, Mr. Daly, do you have any difficulties with maybe a foreign person or a person of a different race coming to America and getting in trouble? Do you have any difficulties being fair on a jury with that proposition?
No, I think all people should be treated the same, doesn't matter.
Okay, and Mr. Burleson, how do you feel about that?
I totally agree with that.
Ms. Ford, what is your thought on their answers?
It doesn't bother me that he's from Nicaragua.
Okay, and Mr. Byrd, is that correct?
That's correct.
Okay.
Yeah, I feel the same.
Okay, good. I had an opportunity while Mr. Garcia was going over some information with you to read through your juror cards, and I would like to ask some very specific questions, and if there's any personal information you think I'm delving into, please feel free to let us know and we can approach the judge if there's anything that you feel is inappropriate to be asked. But please forgive me, I need to ask on Victor's behalf some of these questions. For instance, Mr. Burleson, I notice in your juror card that you are a student, is that correct? I'm sorry, that you're a student, is that correct?
Yes, sir.
And where are you studying?
UT,
Okay, and how old are you at this time?
28.
Okay. I've also noticed that you have a religious preference of Baptist. And myself being from the South, I, for instance, grew up in a small town with a very strong Baptist church there, parents included. Do you have any deep-seated feelings concerning drinking?
I don't drink, but I mean, I view, my religious beliefs as my own business. To each their own, live and let live.
Okay, but is there anything as far as the reason that you don't drink that you would hold it against someone who did choose to drink?
No, I don't think so.
And one of the reasons I ask is because, quite frankly, the issue of drinking, obviously important in this case, Victor did have something to drink. And as was stated earlier, the issue may fall down to simple consumption and driving not being illegal versus intoxication or drunkenness. But if there's anything that would cause you concern about that at this time, we sure want to know. Mrs. Ford, you put on your juror card that you had actually been a witness in a criminal case. Is that right?
Yes, it is.
And how long ago was that?
It was 3 years ago.
And were you a witness on behalf of the prosecution or a witness on behalf of a defendant?
I was a witness for the state.
Okay, what kind of case was it?
It was an assault.
Okay. Was there anything about that experience or that case that you think would affect your job here today as a juror?
No, that was a separate case.
Okay. I also noticed that your husband is an attorney.
He is.
What type of law does he practice?
He works for the Attorney General.
Okay. Is there any particular group over there that he works for, or is he in the general counsel's office?
He works in enforcement.
Okay. And
does habeas stuff.
Okay, death penalty. Is that right? Okay. Is there anything or connection of things that he's told you about his work that may cause you to think, well, maybe I can't be fair in this particular setting?
No, I think that I can be fair because of I know that at the far end of the justice system, there's all these checks and balances, and I feel that the people aren't wrongly convicted, because of those checks and balances.
And because of the system?
Right, because of the
Okay.
system.
You think that it works?
Right.
Mr. Byrd, is there anything, I've read through your card here, is there anything in your background, for instance, have you had any relatives that have been injured or had any bad experiences with drunk driving?
No, not at all.
Okay, where are you from originally?
I am from Dallas,
How long have you been here in Austin?
about 2.5 years.
Have you ever been called to jury duty here before?
No, I have not.
And finally, Mr. Daly, let me get with you. I noticed on your card that you checked that you have a family member that's a peace officer.
Oh, yeah, it's my brother.
It's your brother.
Yeah.
Where's your brother work?
DPS, Highway Patrol.
Oh, and that would be here. Does he work close to us here in Travis County?
Right.
Okay. How long has he been a DPS trooper?
Geez, probably about 12 years. We see each other about 4 or 5 times a year.
A year, okay. Troopers are really on the front line of a lot of DWI arrests. Have you ever talked to him about that subject?
Yeah, we talk all the time about it.
Okay.
He talks about his work, but I mean, it's really nothing you don't see in cops. You know what I'm saying?
Right. And going on with those things that you see in cops, do you think that you might be, granted that the officer that made this arrest is not a DPS trooper, he's not, doesn't go through the same training, things like that a DPS trooper would, but do you feel like there's some kind of kindred spirit that you would have with just officers in general?
No, not really.
Okay. Do you feel like you'd be able to look at the officer that made this arrest just as you would any witness, period, not giving them extra credibility because of their badge?
I think I could do it.
Okay. Well, one of the things that came out during Mr. Garcia's discussions with you was he said we want to make a point that this is not about simple consumption and driving, and I think he was speaking with you. Is that right, Mr. Burke?
Right.
Quite frankly, that is something that is important to us because, as we said, there's no hiding the ball here. Victor had some beer that night and then drove. When we talk about simple consumption and driving, do you have any problems thinking that a person could have some beer and then drive safely?
No, I think, have a couple beers with dinner or, a glass or two of wine, and I think someone's fine to drive.
Okay. Ms. Ford, how do you feel about that?
About drinking and driving?
Well, do you think that someone can, and I'll call it again, simple consumption, do you think that somebody could have some beer and then drive and do so safely without being intoxicated?
I guess it depends on the person, and it depends what some beer is.
Okay. And are you willing to at least sit through testimony to, well, as you say, judge that person based on what events occurred that evening? Or are you saying that you think that any beer at all would cause somebody to be intoxicated beyond the law?
No, I'm saying that it depends on the individual,
Okay.
and I'm willing to hear testimony.
Okay. Here again, Mr. Daly, for instance, on I'll say it again, simple consumption, do you think that somebody can drink and drive safely?
Understood.
Yeah.
Yeah, I mean, I think I've even heard when they actually drive better, after a couple years, because they're worried about being pulled over, so they actually pay attention.
And is that something that you experienced personally?
No, but
Okay, but maybe you've known people that you
Right.
think that was applicable?
they said it.
Okay. And how do you feel about what he just said, Mr. Bird?
I'm just laughing.
Do you think that would make you drive better?
Well, I don't know if I would go that far, but the simple consumption, like you said, if you don't push beyond your limit, I don't see a problem with it.
Mr. Burleson, one of the things that will happen in this particular case is a police officer will testify. And at the end of the trial, I'm going to ask each of you to find my client not guilty. And sometimes people look at that saying, well, I don't want to say that the cop was not truthful or the cop was not proper in his actions. In other words, they may look at it as a vote against law enforcement, as opposed to the strict job of what we're here to do and that to decide Victor's future. Do you have a problem finding somebody not guilty, knowing that it's going to be testimony from a police officer who's trying to convict him?
No, I don't think so. I think, once they're in a courtroom, they're just like anybody else. They're a witness.
Okay.
They've seen something.
Okay. Ms. Ford, how do you feel about that?
I'm sorry, I wasn't listening.
Well, as far as, the main witnesses, and probably the only witnesses for the state, are going to be a police officer or maybe two. And at the end of this, obviously, as you may be aware by now, I'm going to ask you to find Victor not guilty because we are here for that reason. Do you have any personal bias or prejudice that you would think, well, this is a vote against law enforcement, I just can't do that? I mean, in spite of whatever the evidence is, maybe I feel that he really wasn't intoxicated, but gosh, I don't want to have to look those officers in the face.
No, I'm just gonna take the law as the state presents it, and I'm gonna follow the law.
Okay, you're going to take the law as the state presents it.
Right, as the court directs.
Okay.
The court directs me.
Okay, so but you think you can do that verbatim? The charge that the judge will give you, you can follow that?
I can follow the law.
Okay. One of the things that will be in that charge, Ms. Ford, is that Victor is presumed innocent. It is not just an idea. It is a tool that you will use during your deliberations. It will be written in the charge that says you are to presume Victor innocent. And that means that as he is sitting here right now, if we started to deliberate, you would find him not guilty because there's been no evidence presented against him. And when I talk about being presumed innocent, it's not just applicable to citizens. It's applicable to Victor, even though he's not a citizen. It is applicable to all those persons who come in front of this court, in front of this judge, and in front of you as a jury. Is there anyone here that, based on the things that we've said so far, which are not evidence, thinks, well, gosh, he must have done something, or he wouldn't be here? I mean, he must be a little bit guilty, or he wouldn't be here. Mr. Byrd, how do you feel about that?
I think, I believe, you're presumed innocent until you're found guilty in a court of law.
Okay. Mr. Burleson?
Giving the benefit of the doubt, I figure that I don't think the, police officers just pull someone over because they're bored. I mean, something had to cause alert the officer's attention. I don't think that's enough to convict him.
Mr. Daly?
I agree with that. I think something happened, but who knows?
Pull the board over here. If you're on our map, pull the board
You may.
over here in front of the jury. Mr. Daly, what do you think about that? Is this close enough for you to, if the government buys it, it must be good? What do you think about that?
I don't think that's necessarily true. I've heard these horror stories about the Army buying this crap and paying the most high prices for it.
Okay. Mr. Burleson, what do you think about that?
There's a reason why there's a phrase good enough for government work.
Okay. Okay. Mrs. Ford?
I'm assuming you're gonna bring this is in reference to the intoxilizer.
Sure, that's correct.
I think the intoxilizer is good, yes.
Okay, do you have any personal experience with the intoxilizer?
No, I just know that it's part of the legal definition that we were directed to, and so I believe in it.
You weren't in class last week, were you?
My name's Cora. I'm 40 years old.
Mr. Bird, how do you feel about what Mrs. Ford said, as far as, do you think that it is an infallible machine? Because the government buys it, it's got to be good.
5 minutes, Mr. Olin.
No, I don't believe it's infallible. I mean, like Mr. Daly was talking about $500 toilet seats, you know, just because the government buys it doesn't mean it's perfect.
There is probably going to be some evidence concerning an intoxilizer machine. And one of the points that I'm trying to bring up here is to get your impressions on that. For instance, Ms. Ford, I appreciate your candor as far as your feelings on the validity of that machine. Let me throw this out to you, Mr. Daly. Do you know anything about the intoxilizer machine, first off?
Not really, just something like you blow into it, right?
Something you don't have any background or have not experienced the machine before.
No, my brother just, his stories told me.
And what has your brother told you anything about the machine?
Not really, just, occasionally he'll have people blowing the machine.
Okay. Are you willing to listen to evidence that the machine may not be all that it's cracked up to be, even though your brother uses this?
Right. I think you'd be open to that.
Okay. Mr. Burleson, how about yourself? Are you willing to listen to evidence that, as I say, the machine may not be all it's cracked up to be?
Oh, sure. I mean, it's a machine. It's like your car. If you don't take care of it, it doesn't run.
Okay. The last thing that I think I would like to speak to you about is the burden of proof, and that is that as we sit and stand here right now, Victor is innocent. He's presumed innocent at this point, and he's presumed innocent by the charge that he will get from the court. And that is presumed innocent beyond a reasonable doubt. That definition will actually be defined in the charge, and rather than go into it at this point, suffice to say that you will have to decide whether you believe beyond reasonable doubt that he is in fact guilty of driving while intoxicated. If we looked at this rail right here as evidence, and midway, let's say that all the evidence presented in the case, if you felt it was 100% that he was intoxicated, you would have proof beyond all doubt. That is, in other words, you either saw it, you were there, the evidence is so strong there is absolutely no doubt in your mind, and that has filled this scale, the evidence scale. Let's say that that's what this is. I can't tell you exactly where on this scale beyond a reasonable doubt, because quite frankly the requirement is not beyond all doubt. But it is beyond a reasonable doubt. And I can't tell you where on this scale of evidence that falls. What I can tell you is that it is the highest burden that our Constitution has placed on our justice system. It's not like a civil case where it is just simply a preponderance, maybe a little bit more chance than not. It's not even to a point of where if the government was trying to take away your kids, the evidence that all they need is clear and convincing. It is actually beyond that. It is more than if the government were trying to take your kids away.
Time, counsel.
Thank you very much.
What I would like to do is to, Tom and Gus, assume you had one strike. Who would you get rid of and why?
Okay. Well, Your Honor, at this time, may we approach on a challenge for cause?
Sure.
Okay.
Please.
I'm sorry.
I would like to challenge for cause Mrs. Cora Ford, the 40-year-old person who wasn't in class last week.
Ms. Ford, assume you're at the bench and answer counsel's questions.
Okay.
Ms. Ford, one of the things that concerned me during our questioning was your undying belief in the instrument itself. And what I'd like to know a little bit more of is, are you saying that if there was any evidence at all that a machine produced a result greater than the legal limit of .08, you would automatically at that point think that Mr. Alvarez was guilty.
No, that's not what I was saying.
Okay, and if you could, please clarify a little bit for me so that I can hear it. What is your thought on the machine gun?
Well, I believe it's a measure of intoxication, and I believe it will be strong evidence if you offered me a breath sample that was over .08, especially if you had other intoxication clues like the field sobriety test, that it would be strong evidence that your client was guilty.
And forgive me if I didn't hear you correctly, but during the voir dire, did you say that you would not be able to consider any controverting evidence concerning its...
No.
Okay.
I can hear other testimony.
Okay, thank you. That's all I have at this time, Your Honor.
Counsel for the state?
Make a challenge for cause on Mr. Byrd.
Go ahead.
Mr. Byrd, for clarification purposes, tell me if I didn't hear you correctly, but when I was examining you and asking you questions about the lack of bad driving in the DWI arrest, basically I said if the policeman said that there was no bad driving other than 10 miles over the speed limit, that you'd have a problem with that person being arrested for DWI. Is it that you're going to hold the state to a standard that would be beyond what the state is required to prove? In other words, if I don't bring you evidence of bad driving, is that just in your mind automatically you couldn't convict a person for DWI?
No, I think I'm just saying I want to be real careful convicting someone for DWI if there's no scientific evidence that someone was drunk or someone was legally intoxicated. That's what I want to be careful doing that. I think, we're messing with someone's life here.
Let me ask it a different way then. Could you envision yourself, given other evidence of intoxication, being able to convict somebody for driving while intoxicated if the police could not testify to any bad driving?
Well, I think if they could convince me that someone was drunk and they just pulled them over for speeding, I could convict them.
No other questions?
Okay. I think you just answered my question as to who the two jurors were that you would probably have struck because you weren't able to get them for cause. Am I incorrect? Would you still have struck Ms. Byrd?
Ford.
Ms. Ford, I'm sorry.
Oh, definitely.
And you would have
Mr. Byrd.
Okay. What I'd like y'all to do is to, in the state goes first order, Gus just kind of discussed your general theory of the voir dire with the class, and then Tom do the same thing, and then when both of them have finished, then y'all can, including the jury, can ask questions. So, yes.
Well, first of all, I've been a defense lawyer since 1995. And I prosecuted from 91 to 95. So it's been a while since I did a DWI voir dire from the prosecutors, and I only saw Bill Allison this morning around 9:30, and he handed me his problem. So there's a little bit of rust there. But my first pet peeve, one of the things that I would have objected, but I said I'm just not going to mess up Tom's train of thought. But one of the things that really one of my biggest pet peeves when I was a prosecutor is this notion of the prosecutor standing by here and saying, well, my client is a good old boy, and he goes to church every Sunday, and he's a A student at college, and we always, there's several defense lawyers that would do that, and we started to generate an objection to saying, this is just his way of getting around putting his client on the stand, and so that's one of the things that that were highly fought issues. But so that's just to get my pet peeve out of the way. Don't allow the prosecutor the defense lawyer to put in evidence of the defendant's character at voir dire, because if you go to most of these trial advocacy schools on DWI that are slanted towards the defense lawyer, is you never put your client on the stand in a DWI case. I mean, it's just, that's kind of a good rule of thumb, and many defense lawyers can circumvent that by doing what he did. But my general theory of voir dire, from a prosecutor's standpoint, is first of all, it's very hard to do because 95% of DWI board hires that you see prosecutors do is they literally lecture for 45 minutes to an hour, and I, as a defense lawyer, am sitting there, with my pen and paper ready to take notes and of what their responses are, and at the end of a prosecution board hire, and my sheet, most likely than not, is blank. It's just blank because the prosecutor's feeling like he's got to talk about the definition of an intoxication, he's got to talk about the burden of proof, he's got to talk about police officers and witnesses, he's got to talk about the intoxilizer, and that prosecutor never gets around to talking about anything having to do with what your attitudes as veneer members are. So as a prosecutor, you've got to work really, really hard in order to try to just get people to talk, because in a misdemeanor case, you only have 3 strikes as peremptories, and if you get people to talk, I can tell you, almost even when the prosecutor, as a defense lawyer now, as a prosecutor is doing his voir dire, her voir dire, I can already pick out the 3 people I don't want. And I'll sit down with my client during a break and say, do you see the real stinkers on this panel already? And so at that point in time, they jump out at you. And if they don't jump out at the guy, if the prosecutor doesn't get out any responses during her portion of the voir dire, then it's up to you to have the person, the panel start talking, so that you can identify them. And they'll jump out. Tom did a much better job than I did, because frankly, I didn't look at those cards because I just didn't have time. And he was able to pinpoint some things. Those cards are very important. Many times they're available the day before a trial begins, and you can look at them then, so that you can identify them. The last trial that I did was 2 weeks ago. There was an APD detective. There was a topless dancer. She called herself an exotic dancer.
You got the panel that we
Yeah,
had.
that was the worst thing.
Yeah, I ended up with that panel. That
Oh, I know that panel.
I'm trying to think if there was four real.
4 police related, like, there were 2 Army guys, retired Army.
There was a Budweiser distributor.
Yeah.
I mean, if there was a DWI trial, and there was a strip dancer, a cop, and I don't remember, there was a 4th person on there that.
Gary Cohen's paralegal.
Yeah, Gary Cohen's paralegal, that was it. So, those cards are important. Prosecutors are, you just got to make them talk, because so many, that trial that I did, the prosecutor, I wish that you could have gotten Beth Weinman here, because Beth Weinman did the best, she did the best DWI prosecution voir dire that I've heard in about 7 or 8 years. And it was just devastating. I think at the end of that voir dire, I was just like, take a vote now, and I bet you like 18 of them will vote guilty. I mean, that's how good it was. And she was, in a good voir dire, she wove in the facts of the case in her hypotheticals. She went step by step through the field sobriety tests, the refusal of the intoxilizer, and she just, it was brutal, Ken. I mean, it was just, and it really flustered me when it was my turn, because most of the time, and I've tried cases here, and I've tried them in Georgetown, I've tried them in Lockhart, most of the time I'm just like, God, good, this prosecutor's bored him to death. He hadn't asked one of them to say except, well, I can see I will assume by your silence that the answer is no. And I'm just like loving that, because I'm the first guy that wakes them up as when it's my turn as defense lawyer. So Beth really, really put me on my heels, and it was devastating. I mean, I promise you, if people had been honest, 4 of them would have voted for guilty at the end of her voir dire. I mean, it was brutal. I mean, and I told her afterward, that was one of the best voir dire. And what she did was she wove in the facts of her case, very, very, very craftily, very, very smart, best I've seen in many, many years. And she did this line of questioning about, which I wanted to do here. First of all, most of the courts here in Georgetown, Lockhart, and Bastrop, they'll give you 45 minutes to an hour. She got into this thing about, what is it, does somebody have to be hurt? Somebody have to be hurt in a collision for you to convict? And no. what if I told you that in this particular case, a hypothetical, that nobody was hurt, it was just a traffic stop. And one of the ladies in the front, well, hell, he just got lucky. And I was just like, wow, she was already, getting that juror to say that my client was just lucky to have not killed anybody, and so it was just devastating for her. But she got him to talk a lot, and when she found that one, she used that detective, but she didn't abuse that detective, that APD detective. She didn't just use him to poison everybody, but she would kind of like float over to him, well, what do you think, and how does APD handle these kinds of things? And she got that guy who's like a pillar of righteousness, and was able to just get everybody going that way. And if you find somebody that's good for you like that, you can really, and like I said, if you can get them to talk, they'll pop out right in front of you. And if you can get rid of those bad ones, and then those really bad ones, you start developing your strikes for cause, so that you can use your strikes on peremptories on people that you can't get rid of for cause. And the big mistake that I made on that one was Hampton was trying that case, and he was granting causes like, somebody said, one guy got up there and said, I don't think I can do it because I was a Vietnam veteran, I'm feeling very claustrophobic, and if I don't get out of this room right now, okay, you're excused. And he granted like 5 causes, and so we were down like number 16, number 17, number 18, and we hadn't talked to those people back in the back. Neither me nor Beth had talked to the person in the back, and so we ended up with jurors, 1 or 2 jurors that nobody had talked to, because neither one of us anticipated that the judge was going to grant that many strikes for, if it had been a regular Travis County judge, that those strikes wouldn't have been granted. So you've got to make some effort to talk to the people in the back.
I'm just curious, first off, did we get any of the information that y'all were given?
Secrets.
The secrets.
You got that I didn't drink, but you didn't get that my older brother served time for burglary.
Okay. Any others?
You got my brother, but that was on the card for the police officer. But then you didn't. I don't drink, and I don't approve others to drink.
Okay.
Church of Christ or something.
Okay, so we didn't get that. Okay. Well, I mean, obviously the practicing.
You got all mine.
I got all that one. I got Mr. Bird. Did we get?
Well, I had been arrested for DWI before and got out because I blew a .09.
Okay.
So
Okay.
I didn't agree with the stupid human tricks.
Okay. Well, obviously, as far as the goal, I don't want to repeat everything that your good professors have already said, but even if it's bad information, you want it, and you want it to get out in the open, and the reason is because there's no other way for you to find out who's good for you, or for that matter, who's bad for you, whether you can get them for cause or not. And it's uncomfortable, but you have to get used to soliciting the bad information, even though that can taint the panel a little bit. It's just the way it is. But what you end up doing is you get rid of Cora Ford, who, she may have at the challenge stage kind of said, oh, well, no, I know I'm supposed to behave like a juror, which means I have to be fair. Truth of the matter is, she's already pretty much told you that if there's scientific evidence of anything, she's going to kick you in the tail. And so the goal is to solicit the bad information, even though it does have a possibility of tainting that. Now, as far as the strategy, I will say that in this particular case, since Victor blew a .12, and the legal limit now is .08, granted they'll change that in the scenario, I think, to .10 sooner or later. You have to do something to start putting some doubt as to the machine. I mean, period. You have to do that. It's interestingly enough, I find what experience I have, most people do not hold it against someone for refusing to blow. That is, they're willing to say, I don't know if I would blow in that machine. Because they're still thinking back 20 years when they were in high school and they heard if they bid on a penny before they blew, it would go crazy or whatever. I mean, all these wild stories that everybody's heard. And it just fascinates me that most of the denier panels, they don't really hold it against someone for not blowing, but by gosh, what they do is they turn that machine not into an exact scientific evidence, but as part of the whole. Say, well, I don't know if that machine works 100%. Maybe he wasn't 0.12. Maybe he was just 0.10, but that's still that much over 0.08. They end up using that as kind of icing on the cake, or the final nail in the coffin. And so, at least in this particular case, where you have a breath test, you have to start attacking it somehow. And this is the best that I've seen. It sounds in that lane. This is the best that I've seen so far. But what typically happens is there's always 3 or 4 guys that just can't wait. They're like Rush Limbaugh people. They just can't wait to attack the government, and for whatever reason. And you'd be surprised. They kind of that's your little revenge for the other bombs in there. People who my mom was killed by a drunk driver, and that guy still drives by my street every day. Those things which influences the rest of the panel, which you have to get to. So I don't know that I can't say that my specific theory on this is X, Y, and Z, but I can tell you generally there are things that you need to address, and particularly for me, it's the instrument, because, like I say, it's not that they use it as an exact science as much as they use that as part of the whole. That has been my experience when I've talked to jurors. So,
Any questions about style, substance, or what you did or didn't do?
Had to do with the jury.
I don't think you have to ask that question.
The interesting thing about that jury, well, first of all, it was a guilty verdict. The interesting thing on that jury was that it was a video case, and the defendant on the video refused to waive his right to silence and at the interrogation portion. But the officer plunged into questioning anyway. Where are you coming from? Where have you been? How much have you had to drink? And then he got to the standard question of, do you think that you've had too much to drink to be driving tonight? And the guy says, yes, it's true, I've been drinking too much and I shouldn't have been driving. Well, because of a motion to suppress evidence, I was able to have the audio portion of that videotape suppressed, and so the jury didn't hear that. But the flip side of that is that it prevents me from putting my client on the stand, and frankly, I didn't want to put him on the stand anyway, regardless if he had not said that. But what happened was that I had the jury on my side talking to them afterwards, and well, we agree with you, because I go to this long thing about what Mr. Bird is referring to, is that I try to get the jurors to see that those field sobriety tests are really police coordination tests, like Gary Trichter calls them, and that they're really very hard to do. And so the jury was like, we were with you on that, and he looked good on the video. But we couldn't overcome the bad driving facts, and the policeman had said that he had gone into the grass 2 times, had lurched into his lane, and had forced him to take the policeman to take evasive action. And so my client was like, guys, I didn't drive into the grass, I didn't do that. I said, well, you can't tell them your side of the story, so you're out of luck. And so the jury was like, basically, we couldn't overcome the bad driving. They just convicted on the bad driving in and of itself, and took the policeman's word for everything else, I thought. But it was an interesting case, but they found him guilty on that deal. And by the way, the Budweiser guy ended up on the jury, and the topless dancer ended up on the jury, and I got the cops stricken for cause, and the Budweiser guy was just dismayed that neither one of us wanted him off the jury. He goes, don't you know who I work for? Well, yeah, because every day that he came to court, he had a shirt that said Budweiser on it. Well, but Beth, we were teasing her. She needed about 7 strikes. I mean, that was just a horrible panel for her. But, as it turned out that it was 2 old veteran cops. Huckabee was one of them, and Ehlert was the other one. They were both old time. Kai's been Huckabee 24 years, and the other guy like 12, and so all that brass in the courtroom. It was hard to say no to those guys. And I had no way of rebutting the bad driving facts other than to say, well, no, he didn't go in the grass, did he? Yes, he did. And so, there was really nothing that could be done on that deal, but it was an interesting panel. And I guarantee you, one of the neat things about juries is that the dynamics in the room, because I guarantee you, my client and I, this was one of the more observant clients that I've had. Sometimes, I had a trial once where it was a client was in jail for sex assault of a child, and he was filling up yellow pads of, this is the questions I want to add you to ask all my witnesses, and here's a list of all the witnesses. And he would fill up like 20 pages of direct examination questions and theory of the case, and then I told him, I said, great, this kind of guy I'm gonna have to work with, and I'm gonna make him a real involved partner in the voir dire selection and stuff. Well, during voir dire, I was concentrating on the panel. I was standing up and I was assuming he was taking notes, and then we got back in the room afterwards. And, okay, tell me what you think. I don't know. I wasn't paying attention. I was like, I tasked the bailiff, and then the bailiff said, yeah, the guy was with his head down like this. But this last client in that case there, he was like, Gus, I feel real good about this. And there was a black lady on the panel who, she just had her arms crossed during the states, and she was like, I don't like cops, and I've seen cops do horrible things. But it was one of the people that I didn't talk to in the back row, like number 17, who was this engineer at IBM, and he ended up being the foreman. And I just know for a fact that if they took initial vote, that I had 2 or 3 not guilties. But you hear some people talk about, well, figure out who are the followers and figure out who are the leaders. And if you got bad leaders, get rid of the bad leaders and keep the good leaders, and then you don't care if you have 1 or 2 followers. Well, my good jurors were followers, and the foreman, obviously, no one talked to him. That was my mistake, big error. He just slam dunked them and steamrolled the other 2 or 3 that were on my side, and I know that's what happened. I know that's what happened. And you can never predict that ahead of time, how 6 people are going to react in that room back there. But it became apparent after the fact that my 2 or 3 were just steamrolled by a stronger personality.
I think that Gus brought an interesting point, or an important point, that I feel, particularly in district court jury trials, it is always important to have another set of eyes and ears in the courtroom taking notes, because I don't like to take notes. It's cumbersome for one thing, and it also may emphasize who I'm more interested in than others. But if, for example, in county court, let's say county court 5, there's a post at the defense table end of the courtroom where I like to stand and kind of use that like a lectern, since they don't have them. But I would like to have my legal assistant or somebody else sitting over the jury box, because if I'm talking to this juror, I can't see what the person back here is doing. He or she may be looking out the window, or picking their nose, or things that would give me some kind of body language indication of how I am being received by them. And when you're talking about 42 prospective jurors, it really is important to have, like I said, the other set of eyes and ears in the courtroom to not only take notes, but to watch that portion of the jury that you can see. And the other thing is, I was going to ask the jury, Gus probably never got closer than 3 feet from the rail, but Tom got up to it. Did either of those make you feel comfortable, uncomfortable? Did you feel like your personal space was invaded when Tom got up on the rail? Or did you feel like there was enough room?
Yeah.
Okay. I mean, these are we talk about the choreography of the courtroom, and it really is. I mean, from how do I get out of this chair and get around and go up and talk to the witness, and where do I stand? A lot of that applies to voir dire as well, and you don't want to either in final argument or during voir dire get right up in the prospective juror's face. And things like that, you got to give some consideration to preparation. Any other questions? Go ahead.
I've got one about the law itself, as far as the DWI law. Basically, the officer who ostensibly has never met this person before is trying to determine whether or not their mental and physical faculties are impaired, how can they tell not having any previous experience with that person? Is that used often by defense attorneys, have you found, or just what are your general thoughts on the law itself?
Do you mean as far as,
What's wrong?
is the law applied to the defendant as subjective or objective?
It's applied subjectively, isn't it?
The law, they're not required to show what that individual's particular physical abilities are. It's almost like a reasonable person standard, I guess you'd say, or an average person standard.
I thought it was applied subjectively to each person. And if you could show your client in court, that's how they act all the time, and therefore there'd be no deviation from their normal behavior.
Well, no, I mean, certainly I think that is used as defensive evidence, or from the defense side as evidence to show, look, this guy really isn't an Olympic, swimmer, so he can't stand on one leg, or whatever. But the state is not required to show what his normal abilities are, and therefore this is outside of his normal abilities. You see what I'm saying? In other words, I guess it's where you present that.
Right.
And please, Professor Kinship, correct me if I'm wrong as far as that goes, but does that make sense? I mean, yeah, you can certainly show that all day long. As a matter of fact, that's great when you have people that have, you'd be surprised how many people have had, like, knee surgery or something like that, and, well, they can't walk normal. That's just the way it is. So you can put that into evidence to show, here's what the cop really saw, was this 20-year-old replaced knee on this person, or whatever. But it's not that the state has to show, here is what Bob's normal physical or mental faculties are, and now here is why he was outside of those. You understand what I'm saying? Sure. It's certainly evidence to use to your advantage, but it's not.
What I like to do is, and also in a way projecting the humor, I ask him in this situation, like this past summer, did any of you go to Washington, D.C. to see the statue of the normal person? What is normal to you? Are you normal at all times? Are you the same before you've had your cup of coffee in the morning as you are in the middle of the afternoon? Are you the same, if you're normal at age 25, the same as you're at age 50? And just, get people thinking that, well, hey, just how subjective is this, the cop is applying his own definition of normal to what is normal, or is normal to the cop, to how this person is reacting because he's afraid. I mean, do you act the same when you're afraid as when you're not afraid? What is normal?
And that standard is applied, the officer's making an opinion on the street as to whether or not to arrest the person. And I guess if you ask some cops, they say, well, let the court sort it out, But, the standard the cops are working on is, am I making the right decision to okay, well, this guy, I don't know if he's normal or not normal, because I don't know what he's like in real life, so let me just let him go on down the road, because I'm not really sure whether he's intoxicated or not. No, they don't do that. They're going to just take the person off the street, so that they know they're just going to take him off the street, and then they'll say, well, at least I feel my conscience is clear for tonight on this guy, and then if he's not guilty beyond reasonable doubt, that's somebody else to decide. But I think one of the better stories that I remember was Patricia Guerrero was trying a case where the main evidence of intoxication was this really videotape of this really super obnoxiously, unreasonably rude and belligerent person, and you're like, well, okay, we've all seen the drunk. There's some people that just laugh and everything's funny. There's other people that turn into mean drunks, And so they were like, well, this guy here is obviously so, reacting to nothing, and he was blowing up, and well, there's a huge sign of intoxication there, so they put on the evidence, and the defense lawyer makes a decision to put his client on the stand, and, we are all to assume that the guy in his trial, he's sober for that day. Well, he proceeds to exhibit the same rude, obnoxious, unreasonable, angry behavior on the witness stand, and the jury's like, okay, well, that's not a sign of intoxication. You're going to quit this guy. The officer obviously thought that was a sign of intoxication on the street, and was thinking that's not normal for that person, but he just didn't have the knowledge that that's the way the guy is all the time, and that became apparent in trial where he was acquitted. I hope that answers your question.
Another thing, getting back to your normal, is particularly a lot of these video demonstration by a cop, like heel to toe. They'll hit their heel to toe. You can hear it clunk. You know, of course, your client's wearing sandals there in the video room, but you might, or I might say, when you're walking a tightrope or walking a line, is it normal for you to put your arms out?
Like take after take after take.
Yes. Is it normal for you to put your heel to toe? No, it's abnormal. You keep making them. All these tests are actually abnormal physical tests because you normally walk heel to toe. Number one, you don't slam your heel to your toe. You put your arms out for balance. But they try to count that as a negative to your client because he acted normal, even though he was instructed to do otherwise. That may bear on his mental faculties, but they counted against you for acting normal. And it's actually very abnormal to walk in some of the tests that they have. Okay, if there are no other questions, folks, that's it. We'll see you next week. Thank you all.